Hey there, Ruth George with Ruth P. George Law, PLLC, Trust and Estate Attorney. This video is in a series of videos on estate planning and probate matters. These videos are for educational purposes only. They do not establish an attorney-client relationship. Okay, so I'm here on a Sunday night. I've got my workout clothes on. Why? Well, I'm trying to get back a little bit of flexibility that I once had as a ballet dancer. The flexibility that I had allowed me to dance the way I did and also prevented injuries. And flexibility is the concept that I want to bring out and talk about in terms of trust planning. Because with flexibility, we give our trustee options to make sure that that trust can benefit those that we intend to benefit and also allows the people involved to maneuver around roadblocks when they come up into the future. Now, first and foremost, you're working with your estate planning attorney on your goals. You want to flesh out what your goals are, and then from there, work on the appropriate arrangements. And if a trust or trusts are involved, then the appropriate provisions to put in any particular trust. So your goals could be spendthrift protection, asset protection, creditor protection, special needs protection, income tax planning, estate tax planning, probate avoidance, privacy concerns, relationship arrangements and maneuvering around conflicts, business planning, and so on. And once you get those figured out, again, you're working on the appropriate arrangements, and from there, when trusts are involved, the appropriate provisions. So when I mention the next kind of ideas on provisions, it's very generic, but it gives you this idea of flexibility and what I mean. So first, you're thinking about principal and income distributions. Are you telling your trustee you must distribute income and principal in this way? Is there a particular mandate in the trust document? Or are you providing discretion to your trustee? And if so, is it in regard to income or principal? Is there an ascertainable standard involved? If so, does it pertain to income or principal or both? Or are distributions to be wholly discretionary, totally up to the trustee? Now, this leads me to my next idea, where that sometimes there is state statute involved that provides for this kind of flexibility, and you want to know about it and plan around it. So for example, here in New York, we have the power to adjust, and this allows trustee to adjust as between income and principal, and you want to know about it and plan around it. Which leads me to my next idea, that let's say we have a trustee who wants to exercise his power to adjust, but can't because he or she is a current beneficiary or perhaps a presumptive remainder beneficiary. We would want a provision in our trust document allowing for an independent trustee to be appointed, which can be very beneficial. Which leads me to my next point, that there can be circumstances where we would want a different trustee appointed. Maybe a trustee has moved to a state where there will be income tax consequences that we do not want. Or maybe we just want a different trustee in place depending on the facts and circumstances. Or maybe we want a non-beneficiary appointed to act in the fiduciary capacity in regard to investment management. So all of these are ideas as far as provisions in a trust document and flexibility. And I'll be talking some more about this in another video. This is just sort of part one as far as my ideas on trust planning and flexibility. So this is Ruth George with Ruth P. George Law, PLLC, and I'll see you on a next video.